So I have a few thoughts on defending a shaken baby case beyond what we've already spoken about. These are relatively high level, but I hope they're helpful. I mentioned this at the beginning, that sort of the theme of my talk with you is that you have to find a way to level out the credibility gap in these cases, and the easiest way to do it is to make your credibility front and center in these cases. What does that mean? Well, some of the ways you can enhance your credibility are relatively small but important. You cannot fumble on the terminology, right? You need to be referring to the terms by their proper names consistently. This comes up a lot where people think they have a decent understanding of stuff and they get there and the difference between a subarachnoid and a subdural hemorrhage, and they get stuff pointed out to them by the opposing expert or even by your own experts. One easy thing you can do is to make sure all the terminology that you expect to come up, you know how to pronounce it, you know where it is on a diagram, you know how to use it appropriately. But I think you will be surprised, if you haven't done these cases, I think you'll be surprised by once you up your game in terms of your ability to cross-examine and examine, how many mistakes you'll start to see the other side make. You can start leveraging what's really in the literature, what really is true about the evidence base, in a way that may surprise you. Witnesses that seem very effective when they're not truly pushed become surprisingly ineffective when they're put under additional pressure. And many prosecutors have almost scripts for doing these cases, and if you push them to where they have to go off these scripts, they will start to make those kinds of mistakes. Jurors pick up on that, judges pick up on that. But by the time you stand up in closing argument, if you're the most reliable person in that courtroom, it is amazing the additional help that the judge and the jury will give you in trying to resolve some of these issues. Again, experts cannot be a crutch for doing the work in these cases. They cannot be a crutch. It's unfair to the experts, and it will not prove effective. When I talk to experts, I'm amazed at how many of the stories they tell where they have a bad testifying experience. I'm like, how can you have a bad testifying experience on direct examination? And sometimes the experts will explain, the lawyer representing the same client as me never asked me X question, never asked me to explain. I never even got a chance to say some of these points that I intended to say. You have to use your experts in a way that they are supporting the case that you're putting together, rather than you turning to them saying, tell me what my case is, tell me how I should cross-examine, etc. There should not be large gaps in time between when you're talking to your experts. It's not uncommon for lawyers to tell me that they had an initial consultation with an expert. They then sent some materials to the expert, got the expert's initial opinions, and then they don't talk to the expert again for months and months and months until it's on the eve of trial. I hear stories about people talking to the expert out in the hallways before their trial or the night before. That won't work. You have to have a very good rapport with your expert. And your expert may not be prepared to do some of the things that your expert could be prepared to do. For example, somebody has to explain this controversy to the jury. Somebody has to explain this controversy to the jury. Is your expert truly ready to explain the controversy in the same way you're explaining it in opening statement? How are you going to use your expert consistent with all your themes and not just on narrow medical points? Don't over-rely on your experts. Challenging reliability thoughtfully. I believe that this whole construct of shaken baby syndrome / abusive head trauma is going to largely collapse on itself at some point. It simply is not built on enough reliable tenets, which doesn't mean that child abuse prosecutions will stop. Appropriately, they will not. But this notion that you can infer trauma and abusive trauma from some of the findings that they've been inferred, I do believe it's going to collapse. I actually believe it's going to collapse first because of the retinal hemorrhages. I think the retinal hemorrhage beliefs, which have been stated rather categorically, are not merely overstated, but probably altogether wrong. You probably cannot tell anything about whether the child was abused merely from retinal hemorrhages in most cases. And you're seeing sort of a trend away from the dogmatic views of the past towards something much more specific, and I don't think it's going to hold up. But the way that may collapse in the courts is through reliability challenges. In California, I believe you're a Fry state, is that right, or some modified Fry? Most states are what they call Daubert states now. There's been some merging of those concepts to where in some states it's hard to tell what they are anymore. And I do believe that reliability challenges, pre-trial reliability challenges, in some cases are a very good idea, but you have to challenge it thoughtfully. I've seen a bad trend towards defense lawyers believing that, well, I've got one of these cases, I need to file a Daubert motion, and they file a Daubert motion which is just based on whether or not you can shake a child to death or cause these findings. Well, that might not have anything to do in your particular case. They might not even be claiming the child was shaking. They might just be saying the child was abused. Creating bad law or going through the motions, I understand death penalty cases, things like that, you have to do certain things and check certain boxes. But challenge reliability thoughtfully. What can I go after that might be narrower than going after the whole thing? Can I just challenge the eyes, right? Can I just challenge the eyes? Can I just challenge the notion that you can tell if the child was shaken? Challenge reliability thoughtfully. Do not get a form motion that's available on the internet or from some other office, plug in a few sites and think that that's going to work. The one thing that you can do in that process, though, is educate the judge, right? Educate the judge about how weak the evidence base is for some of this stuff. But challenge reliability thoughtfully. It should not be based on a form motion. The opportunities for challenging reliability sometimes are greater than people think they are. This is from the advisory committee note to the federal rules of evidence. The more subjective and controversial the expert's inquiry, the more likely the testimony should be excluded as reliable. Apply that to what we now know about most of these shaken baby syndrome beliefs. It has undoubtedly become more subjective as we've moved away from the triad. At least the triad had the benefit of being relatively specific, right? And it was based on 3 primary findings. Now it's based on this holistic sort of we know it when we see it approach, undoubtedly becoming more subjective. The forensic sciences that are more subjective have been under increasing scrutiny. Bite mark analysis, bite mark comparison analysis, right? You've seen some of the stuff on that. Arson science, been a lot. That's where this is really coming out in the open. They can't defend the triad per se anymore. So now they're trying to say it's a much more holistic, expertise-driven determination. As they do that, it's exposed as being more subjective. More controversial. There's a lot of things that have made it more objectively controversial in recent years. You have the Swedish report. You have some of the other publications and literature that's come out on this. Certainly the media has paid more attention. You have more courts recognizing it as controversial. The Massachusetts courts have recently recognized it as highly controversial. The Michigan courts, Wisconsin has recognized it. There's going to be more and more published opinions that recognize it as controversial. Build around that. It's subjective. It's controversial. It is not adequately scientific to be treated as such in the courts. Go after reliability, but do it thoughtfully. I know everybody from a Fry state always just blows that off because they think it's easier to challenge things under Daubert than it is under Fry. Well, New Jersey recently had a trial court opinion that found most of this stuff inadmissible under their version of Fry, the Jacoby case, 2018. I know there's people in New Jersey that are gearing up. This case has led, there's going to be additional admissibility challenges to SBS AHT beliefs in New Jersey in the coming years. But this case is based on Fry analysis, and it excluded retinal hemorrhage opinion testimony. It excluded testimony that retinal hemorrhages plus subdural hemorrhages presumptively means abuse. It excluded that testimony, and that's under a Frye standard from 2018. Good luck to everyone in New Jersey, because I think they're going to be one of the next courts out with information on this. We talk about SBS and AHT as concepts, but in reality, they're a whole set of individual beliefs. I gave you the major tenets, but within those major tenets, there's a whole set of particular beliefs. Some of them apply in your cases much more specifically, and maybe with much less force than in other cases. So it's really important that you have an elevator speech in your head as to why this case doesn't meet the mold, or at least the mold that they're trying to sell. Old blood. It's remarkable how many of these cases, particularly non-fatal cases in my observation, there's evidence of older blood in the child's head. In other words, there may be some acute blood, some newer bleeding, but there's older blood too. Those of you that have gotten deeper into these cases, there can be multiple explanations for why you would have older blood and newer blood that have nothing to do with multiple trauma. Okay, it can be some ongoing pathology that leads to that combination. Maybe something that traces back to birth, maybe an older trauma that has rebled. Rebleeding is a sort of unusual concept, but certainly a well-established one at this point in these cases. Is there older blood? Is there older blood? If there's older blood, your theory should accommodate. I've seen several transcripts I've read where there's a reference to older blood and then nobody talks about it. Prosecution's not sure what to do about it. It doesn't fit their mold that the child was shaken to death that morning. And the defense doesn't talk about it because I think they're not sure what to make of it. There are answers. There certainly are answers. There are certainly potential answers. Old blood is something that should be seriously looked at, and how does it fit? Heavy reliance on retinal hemorrhages. It's very common in these cases for the doctors to come in and say, if there was just a subdural hemorrhage and the seizure, we wouldn't be here today. But retinal hemorrhages, particularly these kinds of retinal hemorrhages, are very specific for child abuse. That's not an uncommon scenario at all. 10 years ago, there wasn't a whole lot to say about the retinal hemorrhages. Well, there was things to say, but you were clearly overwhelmed if you tried to go against the majority opinion on retinal hemorrhages. The understandings, or what I'll call the rediscoveries about retinal hemorrhages, because a lot of them go back to beliefs that existed before the shaken baby beliefs took hold, have forced the retinal hemorrhage explanations into a much smaller whole. Now they have to argue that it's these particular kinds of retinal hemorrhages or this severity of retinal hemorrhages. Usually there's no picture, there's no drawing. There's some ophthalmologist who was brought in the room for 10 minutes and told it's a child abuse consult. They confirm the child has retinal hemorrhages, and then that becomes the specific retinal hemorrhage. If retinal hemorrhages are a key part of the case, focus on that. Make it about that. Don't just treat that as if it's just one of the elements. You really need to build a case against retinal hemorrhages, but you can't. Evidence of impact family at autopsy. The shaken baby stuff took hold because a lot of these kids, for multiple reasons, don't have obvious evidence of external head trauma. They don't have swelling on the back of their head. They don't have bumps, bruises. They may not have any, anything even seen at the hospital on X-ray or CT or MRI. And so for some doctors, the best explanation, since we know it's trauma, it must have been shaking because the kid didn't have a head impact. But when you get to autopsy, there may be a small fracture found. If the story was a fall, it was rejected at the hospital because we can't find any evidence of a head impact, and so we basically diagnose shaking. If you find something new at autopsy that's inconsistent with the reasoning used at the hospital, focus on that. Expanding head. A lot of these cases, particularly the non-fatality ones, involve little boys with big heads, big or growing heads. A lot of, particularly 6 months or up, 6 months, 8 months or under. You just see a lot of them where the kid's head was born at the 60th percentile when they were born. At the time of the incident, it was 98% expanding head. That usually means something. Sometimes that may not leap off the page what that means, but make sure you get the head circumference measurements. Sick child. When I was writing the book and was reading a lot of these older cases, I think the thing that affected me most emotionally was reading some of these cases which had reports of these children that had been sick since they were born. I mean, just in and out of the hospital. The Witt case that is mentioned in the book, that child was sick at birth, had been in the hospital for a week with a seizure disorder, was in and out of doctor's offices and vomiting all the time. So that was all pushed aside as irrelevant. In fact, there's quite a bit of child abuse literature that says, oh, well, that is why they probably shook or abused the child, because sick children are more difficult to care for and cause more frustration, which is, of course, theoretically possible, but maybe you ought to be looking whether the sickness was a sign of what was to come. Don't let yourself be, again, if the child had a viral infection 2 weeks beforehand, that doesn't mean anything. But if this is a child that has had a chronic health condition or took a turn for the worse a few days before, just because you can't prove for sure what it is, focus on that. People's common sense is, was anything wrong with this child before? Okay? So make sure if someone says, tell me about your case, make sure you at least can articulate reasons to believe that there's something else going on here. Attack the weak. I think it's a huge mistake in most of these cases to treat them what defense lawyers sometimes refer to as reasonable doubt cases. To the extent you buy in that it was probably abuse, but we can't know for sure, that's not going to work in a child abuse case. It's not going to work in a child abuse case. Jurors and judges are not going to go with probably abuse, but we don't know for sure. That might be the proper answer in some cases, but in the average SBS AHT case, that's not going to work. The reality is that the best science indicates, the best medicine indicates that there's just a ton we don't know in this area. There's just a lot we don't know. We're still arguing about, where the blood comes from and where it even comes from in these cases. We still don't know really whether any meaningful percentage of these cases involve shaking. I mean, we're still waiting for the first clearly documented, I'm not here arguing, by the way, you can't shake and hurt a child, but we're still not waiting for the first documented shaking case like we have fall cases. We have children captured on nanny cams being shaken violently, nothing wrong with them. The biomechanical information would indicate that shaking is not a likely explanation for injury in most of these cases, right? But what the best literature does emphasize is we thought we knew things and we don't know a lot in this area. So it's not simply trying to say we're looking for an exception from the rule. We don't even know what the rules are on most of this stuff. And you should present it that way rather than we're trying to fit into some exception to the general rule. If you do this right and enlist the fact finder as a fact finder, tell them you want them to help you, make them feel like they're part of the mystery solving, which means don't overpromise in opening statements. Opening statements are important, but don't overpromise in opening statements. Enlist them as a fact finder. If you can get the jury thinking that old blood means something, they're going to find a way to fit that in to what's presented. Enlist them as a fact finder. But do not shift the burden of proof. I know it's very tempting to want to stand up in opening statement and say, we're going to prove to you this child died of a fall. No, you probably won't be able to prove that the child died of a fall. Even if the child's sick, you still in many cases can't prove why the child was sick. Don't let them shift the burden of proof to you. And parents let that happen all the time, understandably, like I explained. You're at the hospital. Something happened to this child. These injuries are traumatic. We only see them always in shaken baby syndrome cases. Is there anything you can think of that might have happened? And then you get crazy things. Oh, I was burping him kind of hard, or my arm hit the rocking chair, or he had a fall with the babysitter 6 days before. And then the case becomes Children's Hospital doctor saying this looks like shaken baby syndrome, and you're trying to prove that it happened when the babysitter, when the child had a fall when nobody thought there was anything wrong with it. You've let them succeed in shifting the burden of proof to you. You have to find a way, if you're going to talk about these alternatives, you're going to have to find a way to communicate that you are not saying that that is necessarily what happened. Now, against this advice is the notion that there's something attractive when one side comes in and claims reasonable certainty, right? We know what happened. And the other side comes in and is like, oh, it could be this, could be that, it could be, it could be a lot of things. People are going to migrate towards the certainty, which is why you have to start the education from the beginning and hold that certainty against them. They are here to tell you they know things which they do not know, which science indicates is very problematic, has not been validated, is the subject of great controversy, and they want you to take that matter that's a subject of great controversy and take that woman's children away from her. Okay? You have to find a way to use that certainty against them. All right. Literature. Most of us have very little experience examining or cross-examining witnesses with medical or scientific literature. It's not evidence. It does not come in as evidence. The jury cannot take literature to them. Also, it's very common that you're relying on one sentence or two sentences out of the literature and you're not looking at the whole study. And it can become very awkward if you haven't figured out how you're going to use the literature when you go to use it in a courtroom. Is the judge going to let you refer to it? Is there going to be some argument where you're telling the expert it says something, the expert's telling you it doesn't really say that? This happens a lot. People fumble with the literature. You can't win these cases without effectively using the literature. I believe you can't win most of them without effectively using the literature. So here's some tips. And I have a write-up, but it's under Arizona law. I will provide it to the people at the awesome Northern California Innocence Project if they can try and convert it to California law, but it's about how to use literature and the legal principles that apply how to use legal literature in these cases. I mark all of the medical literature that I intend to use, biomechanical or medical, I mark it all as exhibits. Doesn't mean I expect it to get admitted, but I mark it all as exhibits, so it's part of the record. There's easy access to the judge, and there's easy access when you go to show witnesses it. So I mark them all as exhibits unless the court objects. I try to image, if you have the ability to do it, image the literature to where I can call it up on a screen. So I can follow along, the judge can follow along, and the jury can follow along. So you don't have these experts who are saying, what part are you looking at? I don't see it. It doesn't really say that. I like to call it up on the screen and be able to point with it. Now courts do not have to let that occur. There are pros and cons of letting that occur in an individual case. Certainly in a bench trial, it ought to be permissible. But there are rules and principles that apply to that, and the better rule and the weight of authority is you can use the literature that way. Treatises, there's learned treatise exception, but the literature, certainly for cross-examination purposes, so much more effective if it's up there on the screen. So much more if it's up there on the screen rather than if you're mud wrestling with an expert who's denying it and claiming not to have ever seen it or whatever. You have to think through, though, how am I going to use this literature? Because the logistics will overwhelm you if you haven't adequately thought about it. And you have to talk to your expert. What medical literature are you going to want to use? Which parts of it? None of that should be a surprise to you. The impact of having your expert say, there's a study from Belgium that found blah, 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 it's in 2017, versus having your expert say that and say, I want to direct you to page 4 of that study. What's this chart say? Well, this is this chart that showed 20 children that had retinal hemorrhages, only 4 of them were believed to be victims of abuse. But what year is it? Oh, it's 2017, okay? Work on how you use that legal literature. When I talk about those early cases when there was very few doctors to help in those cases, that's all we had, in some of those cases was the medical literature. And it could be very powerful. If you get a judge that's engaged and they're going to follow through and highlight as you go along, then that judge has been enlisted in a way that's very different than just watching the experts spit at each other. Okay? Think that through. The literature can be quite effective in this case. All right, state's experts. Make them admit or deny whether there's a controversy over these topics. Dwell on it. You would concede that there's a controversy about this. A lot of them have heard the talking point where they want to deny there is no controversy or there is no legitimate controversy. If you can get them to say either there's no controversy or there's no legitimate controversy, you've won with that expert. You can spend between now and 2 weeks later, because there's tons of controversy and there's tons of objective evidence of controversy. You can call your expert and say, Dr. Matches, Dr. Fill in the blank was here last week, and said that there really is no legitimate controversy over these issues. Do you agree? Yes or no? Well, that's absurd. There's clearly a controversy. Can you give some examples of how the controversy has been recognized? Make them say. If they say, yes, there is a real controversy, well, that's quite helpful in and of itself. If they say there's no controversy, that's easily rebuttable. If they say there's no legitimate controversy, we'll point out that they've now appointed themselves not only the arbiter of what happened in this case, but the arbiter of what the entire literature should be declared as legitimate. Make them admit or deny the controversy. And by the way, if it's not a child abuse pediatrician, it's a specialist like an ophthalmologist or something, they don't even know the nature of the controversy because they've only read one part of it. So they might be telling the truth. They don't think there is any controversy, and they might be very vulnerable. Are they diagnosing shaking or not? They all know this is a problem. All these beliefs were premised on the notion that these findings were evidence of shaking, but they don't want to say it's shaking anymore because they know that's very controversial. They know that that's very challengeable. So they will say things like, well, it's abusive head trauma. Well, doctor, are you saying this child was shaken or not? Well, we just know it's acceleration, deceleration, which, by the way, if you tell that to a biomechanics expert, that's never a term a biomechanics expert would ever use. Acceleration, deceleration to a biomechanics simply means speed up, slow down. Every kind of trauma, head trauma, is a acceleration, deceleration event. A fall, a shake, another kind of impact. But in any event, if they start getting into that gobbledygook about biomechanics, then you can start to say, are you using biomechanical language? Do you believe that your beliefs are consistent with what's in most of the biomechanical literature? Make them say whether it was shaking or not. I had one trial. It was the only trial I ever had my daughter came and watched. She showed up in the back of the courtroom with my wife, and she showed up at the part where I was asking a child abuse pediatrician, are you diagnosing shaking or not? This went on for half an hour. Are you diagnosing shaking or not? And it got to the point where she finally almost blurted out, yes, I think it was shaking. I just don't know for sure. I felt I had scored this major victory, but to my daughter it was rather flat. But the point is, jurors and judges will pick up how badly they want to avoid answering that question. If they say yes, it was shaking, well, then they've fallen right into the problems with diagnosing shaking, the scientific problems with diagnosing shaking. If they say no, well, then you don't know what happened, and you're talking about some your understanding of biomechanical concepts that's really very unproven. You don't seem to understand very well. None of them, except the most sophisticated, will have any idea what's in the biomechanical literature. They've known to stay out of it, but they don't read it, they don't understand it, it doesn't apply in their day-to-day existence. But if they want to walk into it by telling you this was an acceleration, deceleration trauma, you should be prepared to talk about that. Pin them down on the importance of retinal hemorrhages to diagnosis. They always love to say it's the full picture, it's all the things, but usually they will go pretty quickly to the critical importance of retinal hemorrhages. This is nice for a few reasons. One, the child abuse pediatricians, who are the best testifiers typically, they're not the ones who look in the eyes. They bring in an ophthalmologist more often than not to look in the eyes, or someone else to tell them what the eyes show. So one thing is they'll be them saying, I'm relying on so-and-so. And then so-and-so might not be as an experienced a witness as them. But again, they will more often than not talk about how critically, forensically important the retinal hemorrhages are. And when they do that, then you're in a position to really start talking about how little evidence there is for their beliefs about retinal hemorrhages. The vitreoretinal traction theory, which is the theory underlying why abused children, shaken children have retinal hemorrhages, has been tested repeatedly. They keep shaking every kind of baby animal that they can get permission to shake. And they can't get these kind of retinal hemorrhages no matter how often they shake these piglets or lambs or jackrabbits that have been shaken by a dog. They can't duplicate what they're saying. They say, well, it's a lamb. It's not a human. Understandable, but no matter what tests they do, they can't seem to replicate it. Meanwhile, kids with pneumonia and meningitis and falling off trains and vascular malformations and aneurysms, anything that has a spike in intracranial pressure or they get any sort of blood clot, it can often happen to kids as they approach death. They do get retinal hemorrhages. Make them talk about the importance of retinal hemorrhages. Make them say that the injuries are reflective of extreme force, extreme violence, extreme acceleration, deceleration. They often will say this. This is usually what they were trained. They're going to be anxious to try and support the mens rea thing. Well, then you can usually, in most of these cases, well, where's the grip marks? You're saying this kid was violently shaken so long that its eyes started to separate from one another, that its brain tissue ripped, veins that run across its brain started to ooze and bleed. Where's the grip marks? Where's the bruises? This kid was treated with such extreme force. That is something that jurors can relate to. Now, that's not dispositive, but you might get them to say stupid things like, well, the padding on a human's hands, babies don't tend to bruise on their arms. The babies, you'll be amazed at the amount of rationales that you'll get for why there isn't this kind of extreme force, evidence of extreme force used. This is the most important thing. Chapter 4 of the book is really dedicated to addressing the talking points that have developed in recent years, since 2009 really and before. The talking points that come out in these trials are usually very predictable. We don't diagnose based on the triad. That's something that defense experts like to talk about. This isn't really controversial. There's another one. Consensus statement. There's a consensus statement that's out there that really sets forth the consensus and understandings. It's not retinal hemorrhages, it's these kinds of retinal hemorrhages. If you're not prepared for these kinds of talking points, they're going to have much more impact than you would expect. But I think you'll find if you investigate them, you'll be stunned that they're even made. We don't diagnose shaking, we diagnose abuse. And these are the things that I was talking about that go to credibility, okay? You have to win the credibility battle, and they are using these talking points to preserve their credibility. And if you can overcome these talking points, I think you'll really start to see a much fresher look from the jury and the judges on you. But you have to be prepared for the talking points. All right. Santa Clara. So I mentioned the consensus statement a few times. In the next 2 months, we have a large paper coming out in response to the consensus statement. Paige Caneva's with Santa Clara, the law school here, and the Northern California Innocence Project. Lindsay Herf is with the Arizona Justice Project. This will be out in the next couple of months. And for those of you who have one of these cases pending, this is sort of has many of the same issues that the book addresses in a shorter format, but definitely should help you address what's in the consensus statement. Do any of you have any questions before we shift it back to Dr. Matches?